Prepack works in Poland very well indeed. So far, we have had several dozen cases over the last 3 years, and 3 issues merit our attention. First of all, the prepack in Poland is no soft law. It has been expressly regulated under statutory law. It is the court which approves the prepack transaction, and in this way the transaction benefits enormously from strict judicial supervision. Secondly, the prepack is regulated under bankruptcy law, not restructuring law. Hence, to acquire the debtor's assets, the declaration of bankruptcy is a must. Thirdly, the objective of bankruptcy proceedings is to satisfy the creditors to the highest degree possible. The continuity of the enterprise is a secondary objective. Therefore, if it turns out that it is possible to satisfy the creditors to a higher degree without using the prepack procedure, then the court will not hesitate to strike the prepack transaction. Returning to our opening question, it works like this. The acquirer need not buy the whole enterprise or all the assets, as it may cherry-pick the assets and cherry-pick the employees. The remaining assets will be sold by the bankruptcy trustee by way of regular insolvency proceedings, whereas the remaining employees may be dismissed by the trustee either prior to the declaration of bankruptcy or later. They have no right to demand reinstatement to their position later on. Alas, Article 23, Index 1 Labour and Employment Code is the troublemaker. It was added to the code following the implementation of the Directive 2001/23 protecting the employee's rights. The provision states that the acquirer is jointly and severally liable for the unpaid liabilities owed to the employees. It follows that the transaction of the sale of the business itself is not sufficient to dismiss the employees. Such dismissed employees may demand to be reinstated or employed again by the acquirer. The problem is, it is not clear whether provisions have overriding power, which takes precedence, the provisions of the Labour and Employment Code or the provisions of the bankruptcy law. For one thing, bankruptcy law fails to address the issue at present, as it only states that the sale under bankruptcy procedure is the sale with the execution effect, the execution sale, and hence the acquirer is released from any and all liabilities after the transaction is completed. So, there are no continuing liabilities. There is a heated debate right now in Poland. As you may guess, insolvency practitioners take the stand that Article 23, Index 1 is not applicable to insolvency transactions, including the prepack transactions. But labour and employment experts argue to the contrary. Regarding the influence of the European Tribunal's decisions on Polish prepack transactions, neither of the decisions discussed here apply to the prepacks in Poland. Small steps is not directly applicable in Poland, as in contrast to the Netherlands, the prepack in Poland is strictly regulated under the statutory law and it is strictly supervised by the court, temporary court supervisor, then the bankruptcy trustee. It is a court decision, which element was lacking in the small steps case. The Plesseurs case, the Belgian case, is not directly applicable either, as the prepack procedure is regulated under the bankruptcy law, and the main objective of bankruptcy law, whether in its traditional form or the prepackaged form, is to satisfy the creditors to the highest degree possible. Hence, the bankruptcy court may not grant the prepack application and approve the sale of the assets if the creditors may be satisfied to a higher degree in a different way. Please bear in mind that bankruptcy law does not aim at restructuring. It does not aim at retaining the bankruptcy as a going concern, in operation. It is a secondary objective and merely auxiliary to the fundamental objective, which is to satisfy the creditors to the highest degree. Hence, this decision may not be directly applicable. As a side note, I wonder whether there is some misunderstanding going on regarding the term liquidation, which also appears in the Directive Article 5, Paragraph 1. It seems that the word liquidation is used to mean the end of the business, the winding up. I believe we should revert to the source of the word, its original meaning, which is making liquid, realizing. Hence, the sale of the business. Consequently, liquidation is not one end of the stick and pre-pack is not the other end of the stick. They are not mutually exclusive. The pre-pack is a type of liquidation. Yet, this issue may be controversial, of course. To conclude, I would like to remark that the Polish legislator did indeed notice the tribunal's decisions, and in its latest amendment to bankruptcy law, which will open the floodgates to consumer bankruptcy petitions in Poland, as it makes it much more easily accessible to a much wider number of debtors, once again and thoroughly, Article 317 Bankruptcy Law is amended so that it reads that Article 23 Index 1 Labor and Employment Code applies accordingly. And the million-dollar question is, the burning question is, how to interpret this provision now, as it may be construed to apply directly, or as it may not apply at all, or as it may apply subject to some modifications. Firstly, if we were to apply it directly, it would lead to the collapse of the liquidation procedure transactions, not only the pre-pack transactions. Secondly, in no way does the amendment refer to the exception in Article 5, Paragraph 1 of the directive. What I want to say is that it does not state that it wishes to derogate from the exception to the principle set out in Article 5, Paragraph 1 of the directive, which expressly allows to disapply the protection due to the employees in the insolvency proceedings. There is no trace whatsoever in the rationale for the amendment that the legislator's objective was to amend said principles. On the other hand, ignoring the provision is out of the question, as it seems this was expressly the legislator's objective, to make Article 23 Index 1 Labor and Employment Code applicable to insolvency transactions. Hence, the third observation that this amendment will be applicable only to a certain extent to the transactions which will take place as of March 2020, when the amendment comes into force. To my mind, this provision may only have a limited application. That, first of all, it applies only to the employees bought by the acquirer. So if the trustee, for any reason whatsoever, fails to pay them under the bankruptcy procedure, then the acquirer will be jointly and severally liable for these liabilities. But as it is a joint and several liability, then it should settle it against the bankruptcy estate. And secondly, the acquirer is not obliged to buy all of the employees. It may buy only a part of the workforce. But of course, it must provide arguments for this decision, technical, organizational, economic reasons. And obviously, it is quite easy to argue. Well, these are my own personal observations. How it is applied, time will show. Many thanks for your attention.